Can you put a property with a mortgage into a trust, then have a different buyer take over the mortgage? So there's all sorts of scenarios where this could play out really horribly. And it's impossible for me to just answer this question without knowing the specifics of the circumstance. But I could give a few examples where maybe this is okay and maybe it's not okay. One, a lot of times if people run into financial difficulty, they'll have family members help them pay the mortgage. So if that's sort of what's meant by a different buyer just being a different person, is it going to be a big deal to the bank if you have your aunt or your uncle or a parent or a sister or brother paying your mortgage? Probably not. It's probably going to be fine, as long as it doesn't create some problem between you and them, or even maybe they're giving you the money to pay, so you're getting the money, then you're paying your mortgage. There could be scenarios also where somebody owes someone money and they're paying their mortgage. I mean, not super typical, but if the bank's getting their money and the actual title of the property isn't changing, so it doesn't look like it has changed ownership, those are going to be the big things for the bank, right? They want to get their mortgage payment every month, and when title changes, that's what triggers the bank to think, hey, if somebody new bought the property, why wasn't I paid? So if this title is staying in the trust and someone's just helping you make the payments, may not be a big deal or a bad thing, again, depending on the circumstances. Now, if this is some sort of scenario where you're trying to actually transfer property, and this is why you have a buyer in here, by putting it into a trust and then someone else entirely is moving into the property and they're taking everything over, and it's a way to avoid them actually going onto the title, I wouldn't recommend doing something like this. I mean, I could see it being super problematic. The same as I can see it being super problematic if this is some sort of mortgage payment in exchange for some other service or something you have going on the side, like some side business deal. Don't do stuff like that. They more often than not go horribly wrong and result in really bad litigation. The other thing that I want to mention here about property in general and why we talk a lot about utilizing ladybird deeds in Florida, where the property would remain in the owner's name while they're alive and then only deposit into the trust after they pass away, is a lot of the times due to mortgages on the property. Because when a bank has a mortgage, this is the same also with like homeowners insurance or title insurance, all this stuff is in your name. When you buy the property, you get the mortgage in your name. Title insurance is in your name, homeowners insurance in your name. Sure, you can make efforts to put the property in the trust and then ask to have them added on as an additional insured. But the way banks work with mortgages is when title transfers, when the property goes from one person to another person or entity, that's what would oftentimes trigger a due on sale clause, because it looks like this property is not being retitled, it's being conveyed to someone else. So the bank wants to get paid. They should be receiving their money now for the loan, that the original loan that they had with the original buyer, and the new buyer who's coming on is going to be responsible for getting a new loan if they need a mortgage on the property. Now, we don't see this all that often, especially with revocable trust, meaning people pretty commonly transfer their property directly into a revocable trust, and it doesn't trigger the due on sale clause, or the bank doesn't get involved or try to tell them they have to pay their entire mortgage all at once. So, that doesn't typically happen, again, especially with a revocable trust. However, it's something to consider when you're changing title at all, even just going from the original buyer into the trust. It's something to think with, because the trust isn't the entity that got the mortgage, it was the original buyer. So if you're already doing that and doing something different, and then you want to layer on something else, again, depending on the circumstances, where you have some third party now paying, honestly, to me, it seems like something that could create problems and potential litigation down the road. Again, I would have to know all the circumstances, though, to really weigh in on this. And of course, would have to be in Florida for me to weigh in on this. So my suggestion would be to contact an attorney in your area who is really well versed in real estate law or estate planning and go over the specifics of the situation so they can help you out. All right, so I hope this somewhat gives you some insight into an answer to this question. And if you have any other questions about how property, real property, and trust relate to one another, or estate planning in general, Medicaid, any elder law issues, probates, and you're in Florida, don't hesitate to reach out to our office. We're atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.